necessary for the reason that 51 amendment is not under challenge.
No, we are interpreting.
Yes.
We are just interpreting. We are not going into the merits or demerits of 51 amendment,
Yes.
but the impact thereof. You see, if we accept this argument,
Well,
then
therefore,
a minority institution which is fully funded by the state cannot impart religious education.
correct. And
in spite of Article 30, Clause 1.
My lord, once Section 9 is deleted, compulsory education in Muslim students, look, whatever limited minority status was there, that also went in 51. Compulsory education.
On Article Clause 1 and 3 of Article 30, 28.
No, TMA 5, my lord, I'll just read. So there the context was little different, but 28 is discussed. But my respectful submission would be in facts of this case.
Has this legal position been interpreted? The Article 28 been interpreted?
Yes. Lord, please see page 140, para 144, my lords have. Lord, page, volume 5A, page 651. The discussion in 11 judge bench judgment of TMFI about 28. My Lord Justice Mishra and Justice Padiwal. May I read, my Lord, para 144. It cannot be argued that no conditions can be imposed while giving aid to a minority institution, whether it is an institution run, this is post-constitution.
What page number?
651. Please kindly bear in mind, this is post-constitutional scenario.
Yeah.
Earlier conditions can be imposed. The Britishers were not bound by 30 or any other fundamental thing. It cannot be argued that no conditions can be imposed while giving aid to a minority institution, whether it is an institution run by the majority or the minority. All conditions that have relevance to the proper utilization of the grant in aid by an educational institution can be imposed. All that Article 30 sub-Article 2 states is that on the ground that an institution is under the management of a minority, whether based on religion or language, grant of aid to that educational institution cannot be discriminated against. If other educational institutions are entitled to receive the aid, that's Article 14, my lord. The condition for grant or non-grant of aid to educational institutions have to be uniformly applied, whether it is a majority-run institution or a minority-run institution. As in case of a majority-run institution, the moment a minority institution obtains a grant of aid, Article 28 of the Constitution comes into play. When an educational institution is maintained out of state funds, no religious instruction can be provided therein. Article 28(1) does not state that it applies only to educational institutions that are not established or maintained by religious or linguistic minorities. Furthermore, upon the receipt of aid, the provisions of Article 28(3) would apply to all educational institutions, whether run by minorities or non-minorities.
As so really speaking, right, and therefore the court says that 28 applies both to minority and non-minority institutions. 28 applies to both.
Provision, but because we are right now we are in the mental framework of religious minority.
Once you receive aid or you are recognized within the meaning of 28(3), then the provisions 28(1) applies once you are wholly funded by the state.
And
28(3) applies whether you are receiving part aid or full aid, or whether you are recognized. Then 28(3) the bar comes in, that you cannot compel religious instruction. That's the... And it is not as if 30 overrides 28. The prescription in 28 applies to a minority institution as well.
As well. Lord, kindly...
That's the same.
Yes. Page number?
Page number? TMA 5.
Which page number?
This page is
what is the page number?
550.
This is 5626.
626. 626. While Article 28(1) and 28(2) relate to, your Lordship's got that. While Article 28(1) and Article 28(2) relate to institutions that are wholly maintained out of The state funds, Article 28(3) deals with an educational institution that is recognized by the state or receives aid out of the state funds. Article 28(3) gives the person attending any educational institution the right not to take part in any religious instruction, which may be imparted by an institution recognized by the state or receiving aid from the state. Such a person also has the right not to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such a person is, or if he or she is a minor, his or her guardian has given his or her consent. The reading of Article 28(3) clearly shows that no person attending an educational institution can be required to take part in any religious instruction or any religious worship unless the person or his or her guardian has given his or her consent thereto. In a case where the educational institution has been recognized by the state or receives the aid out of the state funds. We have seen that Article 26A gives the religious denomination right to establish an educational institution, the religious denomination being either of the majority community or minority community. In any institution, whether established by the majority or a minority religion, if religious instruction is imparted, no student can be compelled to take part in the said religious instruction or in any religious worship. An individual has the absolute right not to be compelled to take part in any religious instruction or worship. Article 28(3) thereby recognizes the right of an individual to practice or profess his own religion. In other words, in matters relating to religious instruction or worship, there can be no compulsion where the educational institution is either recognized by the state or receives aid from it. Article 29 and 30 are a group of articles relating to cultural and educational rights. Article 29(1) gives the right to any citizen of a section of citizens residing in India or any part thereof and having distinct language, script or culture of its own to conserve the same. Article 29(1) does not refer to any religion, even though the marginal note of the article mentions the interest of minorities. Article 29(1), it can be linguistic. 29(1) essentially refers to sections of citizens who have a distinct language, script or culture, even though their religion may not be the same. The common thread that runs through Article 29(1) is language, script or culture and not religion. For example, if any part of the country, there is a section of the society that has a distinct language, they are entitled to conserve the same, even though the persons having that language may profess different religions. Article 29(1) gives the right to all sections of citizens, whether they are in minority or majority religion, to conserve their language, script or culture, etc. But I may read further. But for example, Gujarati being a linguistic minority in say Delhi, may provide for an institution and it may have people from Muslim community, Hindu community, Parsi community, all speaking Gujarati language. So what is binding is the linguistic minority character or some kind of a culture. That's what 29 provides.
But Parsi Gujarati is very different from Gujarati Gujarati.
That is true. That is true.
A little more colorful also.
Sometimes extra colorful. So, the Parsi abuse doesn't feel like an abuse. They abuse it in such a way, that lovingly. Your Lordship knows, my Lord says the experience.
Abuse loving people.
What?
I said Gujarati not.
I don't bring, I am not a man in anyway, I am just.
29(2) may also be there. It's important.
29(2).
No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds on grounds only of religion, race, caste, language, or any of.
So we have now examined that. We have examined the 65 amendment, 51 amendment. Now we go to the 65 amendment.
Yes.
That is the orange amendment, right?
Yes.
Orange is basically in section 23, the 65 amendment.
Yes. There is no other change, There are some changes, in, no, there is none.
I think 23. Just let's see what happens.
23, the court. The court shall consist of the chancellor, the pro-chancellor and the vice-chancellor for the time being, and such other persons as may be specified in the statute.
Then subsection 2 is deleted.
Is deleted. The court shall be supreme authority, etc., etc. Please turn the page, my lord, over. And it is given, my lord, advisory function. In accordance with, I'm sorry, ma'am. Statutes. My lord, the functions of the court shall be to advise the visitor in respect of any matter which may be referred to the court for advice, to advise any other authority of the university in respect of any matter which may be referred to the court for advice, and to perform such other duties and exercise such other powers as may be assigned to it by the visitor or under this act. Lord, this
was 65 amendment.
was 65.
What happened in 72? Anything substantive in 72
Yes, my lord. Lord, please come to, my lord, section 23 only. Lord, there is no major change, my lord, in other aspects, except, my lord, some powers of the Vice Chancellor are improved. But 23 in 72 Act, the constitution of the court and the term of office of its members shall be such as may be prescribed by the statute. Subject to the provisions of this act, the court shall have the following powers and functions: to review from time to time the broad policies and programs of the university and to suggest measures for the improvement and development of the university, to consider and pass resolutions on the annual report, annual accounts of the university and audit report thereon, to advise the visitor in respect of any matter which may be referred to it for the advice, and to perform such other functions as may be prescribed in the act.
Sorry.
Wait.
Could the original act 17 and 18 also? 17 and 19.
Yes, Lord, please come to 17.
There is some provision in 19.